Good afternoon, guys. How you guys doing? How is everyone doing this afternoon? Hoping everybody's doing great. I'm tired. I got to sleep really long today. I'm off from work, so I said let me get on here this afternoon and share some of the updates of what's going on with Robert and Robert's case. So I'm gonna wait a few minutes before I get started. Let me say good morning to good afternoon to you guys. Someone, they probably in the bushes, someone got kind of annoyed because I'm saying hello to you guys. They said, why do I have to say hello so long? And I said, why are you mad? Why are you upset? Because I'm saying hello. Well, anyway, I'm going to say good morning, good afternoon to some, good morning to some in other places. I'm going to start from the bottom, going up. Hey, hi, I ride solo. Hey, Lavonda. Hello, Ruthie in the house. Hello, Rhoda. Good morning, Livable Leo. Good morning, good afternoon, Empress. Hello, Rena. Hello, Olga. Nakia. Jana. Forensic Tech. Tawana Blunt. Hello. Black Beauty. Shannon. Hey, hey. Miss Fat, Lala, hello everybody. Hey, beautiful butterfly nest. No, butterfly nest, excuse me. You're beautiful, of course. How you guys doing? I'm glad you guys are here. Hey, Sandra. Hey, Merry Go Round. Good morning, good afternoon to everyone. It's afternoon here, but I know it's morning in the Central Time and Pacific Time, and sometime I think it's an evening in Africa. And hey, Sharon, in Europe, it's afternoon. It's evening, right? Yeah, it's after 6, so it's evening in some places. So hello, everybody. Trying to drink my water down today. Hey, Roland, how are you? Okay. Hey, Alma, welcome. I've never seen you here before. Welcome. Hey, Rose. Welcome. Welcome, Alma. I'm glad you guys are here. Those who's first time on the channel, please share, please like, and subscribe, and hit those thumbs up button, because the more you hit the thumbs up, it gets in the algorithm, whatever. You know what I'm talking about. Hey, Melissa. Good morning. Okay. Good afternoon to those. I am here to just bring up some updates on what's happening in Robert's case. Hey, Unique Thoughts. Okay, I'm gonna stop saying hello because not to frustrate the person anymore. So this is a time where you can go head on, and we're at the 4-minute mark. Those who don't want to watch it, 4-minute mark, you can forward it on. I should have said that earlier, right? But anyway, as you guys know, that filing was done last week on the 1st for bail for Robert Sylvester Kelly. And in the bail, there's some statements that was stated in the documents in regards to the treatment that he has had since being in MCC, and now he's in MDC or MCD, and I think it's MDC, Metropolitan Detention Center. He was in Metropolitan Correctional Center in Chicago, but now he's in New York. He's in Brooklyn, in fact. He's in the MDC. There's been a filing set for bond motion for him to be able to sit with his counsel and get some, for them to work on the case, because the case is less than, it's about 1 month away, because it's supposed to start August 9th. But he has a final pretrial hearing on August 2nd at 1 p.m. in New York. There's been a motion filed. What I'm going to do, I'm going to share with you guys the PACES report, so you can see the timelines of certain things that are occurring. This is for informational purposes. This is just to educate. By the Fair Act rule, I am allowed to share the information. So just for us to be educated. Can someone in the chat put that up so I can put it, link it on my under my the Fair Act notation, if you don't mind. The Fair Act notation. I would like someone to put that up on the. Thank you, Black Beauty. You're the bomb. I tell you, bomb diggity. Okay, I want to put that on there. It says copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for the purpose such as criticism, comment, commentary, reporting, teaching, and education and research. So I had to put that disclaimer out there because I'm about to share some things with you guys. Okay. I'm gonna leave it up here for a minute. You don't have to see my face. You don't need to see my face. But I just want to say good morning. This is gonna be a kind of a lengthy live, and I just want to share it with you guys because I feel it's extremely important. Hey, nobody's anything. I just want to give a shout out to her because she did an awesome job on the virtual rally that she put together. I think she did an awesome job. Thank you, nobody's anything, because you did that. You did that thing, girl. You did it. It was nice. It was beautiful. I feel bad because I didn't get a chance to get my video over to you because I've been busy working. So I just want to give you a shout out because you did a great job. Thank you. Thank you for letting the world see that. You're welcome. Now let's get started because this is going to be pretty lengthy because I just want to share some things with you guys. I know a lot of you guys are not on social media, so you don't get a chance to see some of the stuff that's happening. So the next couple of weeks, everything that I see, I'm going to be sharing it with you guys. If I don't come in the daytime, because my hours are, I work from Tuesday through Saturday, and I work from 9 in the morning till 6:30, 6:45. So if I don't come after 7, I'm gonna try to come daily if possible. I'm gonna try to share everything with you guys that I get. So I need you guys to be very informed. Hold on a second, they're making noise. Hold on. I'm sorry. I have Dallas here and she's making noise. Sorry about that. As I was saying that a lot of you guys don't get a chance to see what's happening on the social media world. So I'm going to try to bring everything that I can, whatever people share with me, I'm going to share it with you guys because the next couple of weeks is very crucial. And I think we need to stay abreast of what's happening. We can't live under the rock. So we have to be informed and in any way possible for us to be out there in the forefront to try to bring awareness to what's happening to him. Hold on a second. She's still making noise, y'all. She's still making noise. Okay. First, I want to give a shout out to Peter. Peter is a pastor in Uganda. I'm not who, Lord Jesus, in Nigeria. I'm sorry, in Nigeria. If you guys remember several weeks ago, like the beginning of June, shout out to Ruthie. Ruthie sent me a video, and I watched the video, and there was a video in regard to Peter. He wrote a song back in 2013. I think it's 2013. He wrote a song, and he didn't do a video for the song until July 2018. And in that song, he said he got a message to give to Robert. It was a message from God that basically don't fall. Don't fall. It was like a warning of things that was about to come in Robert's life. But he told him to hang on, remember the God that the God that his mother taught him about, Christ and everything. So he was trying to get the message to him. He said he tried to tweet him, he sent him a message on social media, but he was never successful in getting that message out to Robert. So lo and behold, God bless Ruthie to send that message to me. Hold on a second, y'all. Hold on. I'm sorry. So lo and behold, God bless Ruby to get that video. She sent it to me, and then I played it on my live. After I played it, I went and I reached out trying to find him. And finally, a month later, he reached out to me. And in the process, I told him what was going on with Mr. Kelly. He didn't know anything that was happening. And then so he explained to me the whole story, how God had given him a message for him to give to Robert and everything. So I asked him about him praying with us and having basically just a support. So he said he would, and then he turned around and he gave me that message that I read to you guys in regarding to what the Lord had told him as regard if America don't release Robert, then basically a warning to America, So the last week during prayer, he expressed to me that on the 1st of July, they're going to recognize Robert, and they're going to start praying. Not only praying, they were going to do some rallies for Robert, some parades and things like that. So he sent me a message on yesterday, and that's how I went out and got the copy of the video. It's out there on his page. I'm going to put the link in there so you guys can share it on your own. You don't have to go through my channel to share it, because it's not about it being on my channel. It's about awareness and things going out for Robert, right? So I just want to shout out to him right now, because he's all the way in the other side of the world, and they recognize the gift that is in Robert, the gift that God gave us. We American have taken out the people that are gifts for granted. And so he is 1,000% behind the push for Robert to be released from prison. From jail, excuse me, not from jail. Sorry about that. So that's where we're at. So in the meantime, last week there was a motion placed in for Robert to get released, so he can a temporary release, so he can be able to have a fair trial. If you guys remember last year in September, when the appellate court rejected the request for Robert to get bond, and one of the things that the appellate court promised in that, I'm going to show it to you all. What the appellate court promised was that he has to have the ability to meet with his counsel, be able to participate in his defense, because he's the one who knows everything that's happening, because he's walking in there blindly, not knowing who the accusers are, and not knowing, because his right is to be able to face his accuser, period. That is a right that he has. And also, and everyone that's saying that certain things like there's guilt, and he is innocent. That is what the law said. I keep trying to tell people that he is innocent. That is the law. And you cannot change the law because of how you perceive. You were not there. Everybody's given their opinion, and they do not know what actually conspire between those individuals. This is what's the sickening part about it. We're so gung-ho and putting guilt on someone when we do not know the truth. And we will not know the truth of what happened until we accept what the law says. We're doing a grave dishonor and this not going by what this America has been standing on, is the law and the constitutional rights. His rights are being violated, and those people don't care. But if it was them dealing with this, you would want your rights to be in place, intact. So the stuff that is happening is not right. I see this as modern day slavery, the way that they're treating this man. You say you're against slavery, but you have this man being treated like a slave, period. Being treated like a slave. This is modern day slavery. You have a group of white people making decision on this man's faith, and he has not been to trial. I mean, the stuff that he's going through, going into the chute, being in there for over 72 days, have not been convicted of anything, but you're treating him like he has been. That is not what America's supposed to be built on. And you, my people, are condoning it. You're condoning it. You're taking a side of individual. You don't know the facts. And I don't care about how many payments or whatever. Do you know in the entertainment world, they tend to not deal with things because it's easier for them not to deal with it? Because if you go into news like all of this that's happening now, had he done fought like he's supposed to fight years ago, he wouldn't be where he is as far as his status. Because when you have given him a tainted image. His image is so tainted now. It's very, very hard to rise above. Just like Bill Cosby. Bill Cosby has been set free. But there are people who are still treating him and treating anybody who stands with him in a negative light. Like Felicia Rashad. She just got a position as a dean in Howard. Now they're trying to take that position away from him because she's exercising her freedom of speech, of giving her opinion of how she feels about something. This is America. We all have the right to give our opinion of how we feel about something. It's our opinion. And now she's being ostracized and being looked upon negative, and they're asking for her resignation. For what? For what? Why ask for her resignation? Because she's giving you her true feeling about it, you know? She has to resign for what? They want her fired for what? Because she gave her opinion? That's how she feels. That's how she feels. And that's the problem with America. You take that, once they put a label on you and they put it in the main media, you know, control main media, right? They put that label on you and you can never get rid of that label. And that's not right. And we're allowing it. We allowing it. When we can, why are Black people so forgiving in how they treat us? Why? Why are we always the one who's got to change our minds? Why? But that's why I thank God for some of my wonderful Caucasian brothers and sisters who see truth, who don't see things in color, but they see things in truth. You know, those are the ones that I rock with every time. Because if it wasn't for some of them, you know, like John Brown and people like that, who help the Negroes and the Black people, whatever thing you want to call us, if it wasn't for people like that, we wouldn't be where we are. You know, like they said, there are some very good white people. I don't doubt there's some very, very good white people, just like there are some very, very bad Black people. You know? So, I'm telling you, Lord have mercy. But I wanted to bring to you guys to light of what's happening, what's the new event as it comes to Robert in his case. Okay. He has been incarcerated almost 2 years this coming July 11th. It will be a total of 2 years that this man has been incarcerated. He's been denied bail several times in both cases, federal cases. He's been denied bail, but he was given bail in a state case. And the funny thing is the same people, same accusation, but he was given bail in the state, but not in federal, because federal has these rules that it's just like crazy. They're allowed to break the law in the federal. I don't understand, because part of the Constitution, it says that everybody deserves a bail, and then all of a sudden they want to use the Bail Reform Act and on him. You know, I don't get it. I don't get it. Okay. Okay. Let's talk about the updates. Thank you, Ms. Fat, for putting that out for Peter's link. Y'all go out there, subscribe, share his thing. Okay. All right. Let's get going. All right. So, guys, you know that he is up for bail. All right. And they gave some of the things, some of the obstacles that they're being faced with in regards to his bail. Okay. Thank you, Nakia. All right, so I'm going to take this off my face so I can show you guys the thing here. Okay, he's being faced with bail, and Ann Donnelly, the judge Ann Donnelly, has given the government until tomorrow to respond to the request for the bail, for the government to respond. They have not responded. They have until the 6th, which is tomorrow, to respond. But in the meantime, somebody else responded. It's pretty sad. Somebody else responded so far. And the person that responded is the two individuals who Robert removed from his case. I don't know what the heck is going on. I don't know what games these people playing. I don't get it. I really don't get it. But I'm going to show it to you guys right now. I don't know why there's a monkey wrench trying to be placed in this. This is irrelevant. I don't understand. The inner fight that's happening with the attorney should have nothing to do with Robert's bail. I don't get it. I really don't get it. But here it is right here. Not Anton. Okay, I'm going to go down. Can you guys see this? Let me go back onto my screen here. Hold on. Let me move out the way. Tell me if you guys can see. Can y'all see it? Make it bigger. You guys see it right there? Who responded right here? They responded to the motion. This is a motion for the 116 is a motion for bond, but they responded. You guys see that? You see that, y'all? You guys see that? The government has not even responded yet, but they have. What is the purpose of this, y'all? What is the purpose of this? I'm just going to let it sit here for a minute. What's the purpose of this? I'll put the link in right now so you guys can see. Hey, Daddy Lola. Yes, y'all, the rally is still going on in New York. Thank you for that post, Daddy Lola. And guys, stop listening to these lies. Stop listening to the lies. There's nothing happening with the rally. It's still going on. People want to try to distract you guys. Stay focused, guys, people. Let's stay focused. Let's not entertain the nonsense that's going on. I'm talking about these videos that people put out attacking supporters, attacking subscribers, attacking. That's just distractions. That's just distraction. It's okay, love bug. It's just distraction. Y'all pay attention. Pay attention to what's happening. And stay on your knees. Pray. That motion is not lying. Steve never went to their hearing and was aggressive when he approached the judge. Constitutional right and not unjust practices favor. Thank you, Yvette. But this is the kind of stuff that's happening right now. If you see that on I'm going to go back to the date. Hold on a second. Let me go back. I'm going to highlight the things that so you guys can see. See, on the 2nd, right? The first, there was a motion placed right here, right? The motion was placed for a bond for Robert, right? And then within the same hour, and I mentioned it to you guys, Judge Donnelly put in an order. She scheduled an order, right? And the order was for the government. She said the government should file a response to the defendant motion for bond by July 6th, and that was ordered by the judge, right? Then 2 days later, these people responded. But the government hasn't responded yet. Whoever's playing games with these important documents needs to stop immediately. Isn't that sad? So that is what's happening right now. That is what is happening right now. So, okay, I'm going to go to the next thing, next topic. So that is, we're waiting for a response from the government, which is going to be tomorrow, the response. And you notice that the response that Leonard put in, is sealed. So that means there's something that most likely is negative. Sylvia, can we see what they say? No, Candy Cane, they blocked it. It's sealed. It's sealed from the public, what he put in. Most of the time when something is sealed like that, is usually something that's negative. That they don't want the public to see until the judge irons it out. And remember, any response that they have, because they have this inside fighting, the judge doesn't want to, which I appreciate that from her, because we don't need to see the craziness that's going on inside. And I do appreciate that, because she wants to keep things on an adult level. You know what I'm saying? On an adult level. So I do appreciate that she's protecting, um, at least she's protecting Robert in that sense, because he really don't need to have to deal with that. And it's sad that this man's dealing with being in prison almost 2 years, and these people out here trying to, and I want to say it the right way, because folks are gonna come in and say something crazy, acting like children. I'm gonna say it like that, acting like children. This man is fighting for his life, but you want to act like children. Yeah, they're acting like children. Why act now when his bond request is placed in? What does it have to do with the price of tea in China? Why? Sylvia, do you think Lena response is against Robert? Kayla, I don't think it's against Robert, but I think it's against the attorney, the two attorneys, and which in turns make it against Robert, because this is a request for a bond right now. This is not time for the two sides to be fighting. The concentration needs to be on Robert and his defense. That's what the concentration needs to be in. And with them doing this fighting back and forth and saying the one person, I don't know what is going to be said. I don't know, but I saw his tweet and talking about the lion. So if you're saying somebody's lying, that means that what is being placed in the document, we don't know what part is lying. We know it says, he said on the tweet that, I'm going to go ahead and hold on. I'm going to read that tweet for you. So, and then in turns, it does affect him. It does affect him. Not directly, but indirectly, it does affect him, because now it's the question of what is submitted inside the document for the bond. Is it valid or is it not? You get what I'm saying? So now it's more time prolonged, and he only has 4 weeks before trial begins. And it's a sad tactic that they're doing this kind of stuff. And then even the Curcio situation is you're taking attention away from working on the case and then doing this Curcio thing, and it's still lingering. It's not even, decision has been not made on whether or not they're going to stay on the case. And then you have a new lawyer that has been brought aboard, and you're still not saying anything about it. It's confusion, it's distraction, and it's nothing but the author of confusion with the enemy is doing this. He's letting these people have these emotions and being caught up in the emotion, and this is affecting Robert. This is affecting Robert. This is not the time for that. This is not the time for this at all. It's not the time. It's really not. It's a lot of distraction, a lot. When you're not focused on the case, not focusing on doing the work it's distraction. It's distraction. And distraction is causing time to just keep flying by and not focusing on what they need to be focusing on. Getting a great defense, I don't know what they're doing, but I haven't even heard of even people investigating some of the stuff, researching some of the things that's being said. I don't get it. Case is 4 weeks away. Trial is 4 weeks away. And for them to do this inside fighting. Come on now. They need to just grow up, be grown men, and move on. The man has made his decision that he wants certain people on his case, okay? If you were such a great attorney, there should have been more motions filed. There should have been more requests and more petition, more real fighting going on. It's sad. It's really sad. It's sad. It's really, I don't get it. Okay, let's get this going now. One second, y'all. All right, now the next thing I'm about to share with you guys is we're gonna have to and remember, y'all. Remember, and Judge Donnelly did mention to Stephen them not to submit any motions. Do y'all remember that? He said let Nicole and Tom do that because they're trying to figure out what they're going to do with the removing of Leonard and Steve. So if they requested to be withdrawn from the case, Robert fired them. Why is it there's still some inside fighting? I don't get it. Okay. Okay, now next discussion, I'm gonna pencil that one for a minute because I'm really in that state of yeah, Ping Boss, you're right. God does work in mysterious ways. All right, next we're gonna go discuss. Okay, we discussed the bond motion, and the government is supposed to reply tomorrow. So tomorrow we should hear what the reply of the government is, and I will bring that into you guys' attention too. I'll bring you out information on that. Okay, the next thing we're going to talk about is this. We're going to talk about there's a couple of other things that was submitted too. There was motion that was submitted in the case right here. The proposed jury instruction verdict form, and they have a couple of exhibits on this one, okay? That's what we're going to be discussing right now. Let me move this over. Okay, you see, defense objection and jury. We're going to discuss that, okay? That's what we're going to discuss next. Hey, Ivan, you're late to class. Candy Cane, thank you for the knowledge and updates. Very appreciative. You're welcome. You're welcome. Okay. All right. Now we're going to go over to some of the documents that was forwarded. That was filed on the 2nd of July in regards to jury's instruction and defense objection, and some of those things. I'm not going to go detail. I'm going to do overview of it, so you guys get understanding of it. If you want me to do details, just say details, okay? Okay. So first one we're going to talk about is the it's what you call the government's request to charge. This is what the government does. The request is charged, and it's going to give the jury a guideline on what the government is charging Robert with, and so it's going to give them an overview how to hey 71 suburban girl, how to navigate in regards to their decisions and things like that. So I'm going to show you this one here. And this is the jury's instruction. I'm going to share that with you guys right here. Hold on a sec. I just want to make sure this is the right one I'm sharing. Yeah, this is the right one I'm sharing. And this is like an 89-page document. And it gives them instruction on, I'm going to make it bigger for you guys. Hold on. Make it bigger so you guys can read it. Can y'all see this? Is that better? That's why I always like to have somebody in the chat so they could tell me, because I got to go to a different screen. I'm going to put my link in here. I can put my link in here so you guys could come on in. Somebody come in, and so you can, I need one person who's not going to, you don't have to show your face. Just let me know if you see this stuff well, because I'm on a different screen. You can see it. Thank you, Shannon. All right. So now this is the government's request to charge. And what this, it's like more of an instruction to the jurors on some of the things, defining certain things on what the case is about in regards to how they should understand, should understand. You can see, okay, thank you. All right, so I'm going to go up. It says here, and this is the person that's the acting United States attorney. Okay, has the preliminary statements, and it's just giving the government's request for. This is the government's respectfully request that the copies of the third superseding indictment and the jury's instruction to provide. So they're basically concentrating on the third superseding indictment and jury instruction. So third superseding indictment is going to give them some definition and guidelines of what is being charged, what Robert is being charged with. Okay. Do you guys want me to be detailed with this, or do you want me to, how much time do you guys have? Let me know if you want me to be detailed about some of this stuff here. But this is basically saying that it's giving them, the court includes following instruction in its charge to the jury, in addition to government requests, and offer additional instructions as they become necessary during the course of the trial. Okay. All right. You said continue, Candy Cane? All right, I will. All right, yeah. So this is going to give some details. Some of you guys, here's the first request that they have. It's a general request, right? And in this request, they're going to give you certain things, all the subjects that they're going to address, right? First one is the role of the court and the duties of the jury, telling the jury what their duties are and how the court is the position of what the court is playing in as far as this trial, and what the duties, what the jury's responsibilities are, what they have to do. right? And they're going to talk about the equality of parties before the court. Everybody's equal. There's nothing, there's no prosecution ahead and there's no defendant ahead. Everything's just equal right now. Then it talks about the jury's communication with lawyers in the court. They're going to give instruction on that. Also what it means to be presumption of innocent, right? And who has the burden of proof, and then what is the reasonable doubt. Circumstantial evidence, what that is, and what direct evidence is. They're going to give them the definition of those things. The function of the indictment, what is not evidence. They're going to give them what's permissible influence drawn from the evidence, and then stipulation and objection. They're just giving jurors some instruction so they can understand what the legal terms of certain things is as far as the court. What stipulations are and objections, charts and summaries, testimonies of the law enforcement witnesses, discrepancy. Discrepancy means there's like a disagreement, something that doesn't match. You know, if somebody gives one thing and another one gives there's like something that's not matching. You know, there's discrepancies, differences. Okay. No interference to be drawn from defendant's failure to testify. Basically, you know, if Robert decides not to testify, there should not be any kind of preconceived notion of guilt or innocence based on him not testifying, because not testifying is a right. It's considered the Fifth Amendment. You know, you do not have to testify at all. Then the testimony of the defendant, if applicable, then the approximate date, how long the case is going to last, deliberation, what the deliberation mean, what it looks like, what will happen during the deliberation, and then also mean and ands and means and or in indictment. Okay, so this is basically the definitions of the table of contents of what is going to be coming forth in these 89 pages. Okay. Any questions if anybody has any question? Yeah, Michael, I agree with you. I agree. Hey, Shell, I agree. All right. Now, all right, let's go. We're going to go into here now, and then continue the question, wisdom, law, basing verdict and sympathy or prejudice, you know, all that. They're going to give them all that. Verdict must be unanimous. So the verdict has to be unanimous. So if it's not unanimous, that means that sometime it will mean, if they all can't come with an agreement, it's going to mean that it's going to be a hung jury. And that's not good. All right. So now here's the request number 2, is the indictment. This is going to give them the definition what the indictment is all about. Okay. The defendant is formally charged with an indictment. As I instructed you at the outset of this case, an indictment is a charge or accusation. It does not mean conviction, people. It does not mean guilt. It's a charge. It's a charge. A charge. All those people keep saying that Robert is this and that, and no, it's a charge that has to be validated. It's not valid. It's just a charge, people. A charge. Charge. Does not mean it's true. It's a charge. And what they do, they give probable cause for them to set an indictment, because some of the stuff that gave some sort of like lenient bending towards for them to go through a trial. It doesn't mean that stuff is real. It's just saying based on the guidelines of what the prosecution has, to have like certain standard guideline, and that guideline fit for them to place a charge. Okay? Doesn't mean it's true. It's just that the stuff that has been given fits within the guidelines for them to charge. Because if it was already guilt of anything, you wouldn't have to go to trial. It would just been, you guys go to jail, right? There's no need for trial. if it all pans out exactly as what it is. But no, it's never panned out that way. You have to go through the process. Okay? An indictment in this case contains 9 separate counts on each of which you will be called upon to render a separate verdict. So there's a total of 9 separate charges that Robert has in this indictment. Okay. Okay. Question number 3. Hearsay. Thank you, Ivan. Hearsay. Thank you, Michael. All right. So now the next one here is knowingly and intentionally. So now they're trying to give them the definition of what knowingly and intentionally mean in the charges that they're providing, that they're given to the jury. So they want to give a jury some instruction on what knowingly and intentionally mean. All of the charges implicates that the concepts of knowledge and intent. As a rule, general rule, the law holds individual accountable for conduct in which they intentionally engage. Thus, before you can find a defendant guilty of the crime charge, you must be satisfied that he was acting knowingly and intentionally. So, guys, in the jury coming to a verdict, they have to find evidence of what the government is saying, the hearsay the government is saying, that, in the charge he says that Robert knowingly and intentionally, meaning that he participating with the knowledge and set forth that his intent, meaning that he wanted to do it. I'm trying to figure out another way to put in the word intent. Intent, like you set out. That's what it is. Intent, set out. Okay. So the jury has to have enough evidence and to show that basically that he knew and he set out to do this. Okay. A person acts knowingly if the acts voluntarily and intentionally, but not because of ignorance, mistake, or accident. See? So they're saying that it wasn't ignorance, it wasn't a mistake, it was not an accident of what? And intent. Intent means it wasn't a mistake, it wasn't an accident, it was not your ignorance of what you were doing. That's what they're saying. Okay. A person acts intentionally as if he acts with a specific intent to doing something law forbids. Like if you know something and you did it regardless of what the law is. Okay. A person acting intentionally if he acts with a specific intent in doing something law forbids. Okay, got that. The person needs to be aware of the specific law or rule that his conduct may be violating. He must act with specific intent to do whatever the law is. It is the law forbids. Okay. These issues of knowledge and intent requires you to make a determination that a defendant's state of mind, something that rarely can be proved directly. So they're saying that the state of mind has to show that he was intending to do this, or he had knowledge of this state of mind. So they're basically telling you that it's hard to really say that what was in the person's mind at the time they were doing it. Okay. A wise and careful consideration of all the circumstances before you, however, may permit you to make a determination as to defendant's state of mind. Indeed, in your everyday affair, you are frequently called upon to determine a person's state of mind from his words and action and given circumstances. You are asked to do so, to do the same here. So, everybody understand what they're trying to give the explanation of what they're saying? Okay. All right, good people. I see I'm not boring you. You're still here. Let me know when you're tired of me, okay? I got all day today. All right, let's go to the next one. We're going to go to the fourth one here. All right, so the fourth request is instruction of request on what they need to be doing here. When y'all get tired of me, let me know. Good afternoon, Reba. All right, here we go. The next one is, it says here, I am not a lawyer, y'all. Remember, I'm just reading. Okay, now it's going to give you some definition about aiding, abetting, and willfully causation. What is it? Causation. All right, that's to cause something. Willfully causation. All right. Many of the Racketeering Act in count 1 and certain of the other counts charges the defendant with aiding and abetting or willfully causing certain crimes. It is not necessary to find that the defendant personally committed those crimes. Did you hear that? It is not necessary to find that the defendant personally committed those crimes as long as the government proves that he aided, abetted, or willingly cause another person to do so. This is so because under the law, a person who aids and abets or willfully causes another person to commit an offense is just as guilty of that offense as if he committed himself. With regards to aiding and abetting, under the federal law, the aiding and abetting statute is Title 18 of the United States Code, Section 2A, which provides that whoever commits an offense against the United States or aids and abets or counsels, command or induce or procures its commission is punishable as a principle. Therefore, you may find that the defendant guilty of an offense charge if you find beyond a reasonable doubt that the government has proven that another person actually committed the offense in which the defendant is charged, and that the defendant aided and abetted that person in commission of the offense. Now, guys, this is the one in regards to Demetrius, y'all. Remember Demetrius talked about how he went to go get the supposedly license, supposedly the fake ID for Aaliyah. So this is where they're saying that Robert aided and abetted. Basically, even though Demetrius is the one that committed the crime, they're saying that Robert aided it and abetted it. Now, I'm assuming, this is my speculation here, that since Demetrius paid the $500 to those individuals, he's making it as if Robert paid it, right? But remember, in my conversation with Demetrius on the recording, he said to me that Robert knew nothing about it. It was Darryl McDavid And it was the attorneys who basically were the one who told him to get this done. And then he said to me that Robert was like a son of his, that if he felt the son was in trouble, he turned around and did this or something like that. Because he said that the attorneys said that, according to them, that supposedly, this is Demetrius' words himself. This is Demetrius' own word. That he felt that he needed to do something. He said Robert knew nothing about it. He knew nothing about it. So how are they going to say he aided and abetted when all his finances were controlled by Darryl McDavis and the attorneys? Robert knew nothing about what was being paid during his, from any accounts or anything. These people made these decisions without Robert's knowledge. Demetrius himself said it to me that Robert knew nothing about the ID thing. So, how is it aiding, abetting, or causing? I wonder about that. You guys have heard Demetrius talk about it in several occasions, several situations in that particular spot. Okay, so I just hope the attorneys know as much as what has been going on, and they've been watching those videos with Demetrius telling different stories, and his stuff was not consistent. And because he was on what was that show? What's that show, guys, that he was on several times? He told different stories each time. TMZ. He was on TMZ. He told different stories. There was one time he looked like he was Professor Gump. He had that fake black hair, and he was telling one story there. Then he looked like the old man that he is on another thing. So he was telling different stories, like if he was different people. And then, of course, he told me a different story, and in my recordings. So, okay, let's go back. In order to find, did I read that part? Okay, let me read it again just in case. In order to find a defendant guilty of aiding and abetting a crime, you must first find the person did actually commit the crime. You must find that some person actually committed the crime. So Demetrius committed a crime. So now they're saying Robert aided and abetted, but Robert knew nothing about it. But according to this, the person has to have knowledge in order for them to aid and abet. Okay. All right. Obviously, no one can be convicted of aiding and abetting the criminal act of another if no crime was committed. But another person is the first player. But the other person in the first place. But look at this. Here's the deal. I'm told that because when I was checking the law on regarding to those people taking bribe, the statute of limitation had come up, and I think it was a 5-year statute of limitation for them to be able to charge those people that took a bribe. So why is it the statute of limitation is up for that, but no statute of limitation is up for Demetrius doing Demetrius' statute of limitation was up too. But why is Robert being charged of aiding and abetting of something that he knew nothing about, as well as these things has a statute of limitation? That's something to get you kind of like curious about that. It's kind of weird. Okay. The next one is, but if you do find that a crime was committed, you must consider whether the defendant aided and abetted the commission of the crime. In order to aid and abet another to commit a crime, it is necessary that defendant knowingly, there we go, the big word, knowingly associated himself in a way with the crime. So they're trying to say, even though Robert didn't know, but the crime basically benefited Robert. Are they saying that? I'm a little confused. Okay. But that he participated in the crime by doing some act helping to make the crime succeed. To establish that the defendant knowingly associated himself with the crime, the government must establish that the defendant knew and intended that the crime charged would be committed. To establish that the defendant participated in the commission of the crime, the government must prove that the defendant engaged in the affirmative conduct and overt act for the specific purpose of bringing about that crime. The mere presence of the defendant where the crime is being committed, even coupled with knowledge by the defendant that the crime is being committed, is merely associating with others who were committing a crime is not sufficient to establish aiding and abetting. One who has knowledge that a crime is being committed or is about to be committed, but inadvertently does something that aids the commission of the crime is not an aider or abetter. The aider and abetter must know that the crime is being committed and act in a way that intend to bring about the success of the criminal venture. To determine whether the defendant aided and abetted the commission of a particular crime or caused the commission of them, ask yourself this question. First, did he participate in crime charged as something he wished to bring about? Second, did he associate himself with the crime venture knowingly and willingly? Third, did he seek by his action to make the criminal venture succeed? If the defendant did all these things, then he is an aider and abetter, and therefore guilty of the offense. If not, the other hand, your answer to any of these questions is no, then the defendant is not an aider and abetter and must not find him guilty. With regards to willing coercion, under the federal law, Section 2B of Title 18 of the United States Code provides that whoever willingly cause an act to be done, which if directly performed by him or another would be an offense against the United States, is punishable as a principle. In order to find a defendant guilty of an offense charged under this statute, you must first find that another person has committed the act constituting the offense charge. 2, you must find that the defendant had a mental state required to violate the offense charge. 3rd, you must find the defendant intentionally caused another to commit the requested act. I further instruct you that to convict a defendant for aiding, abetting, or willfully causing an offense under federal law, you must unanimously agree that the government has proven beyond a reasonable doubt whether the defendant aided and abetted the commission of offense, or that the defendant willfully caused the commission of the offense. In other words, all 12 of you must agree on either aiding and abetting or willfully causing. It is not sufficient that some of you find the defendant aided and abetting the commission of the offense, while others find the defendant willfully caused the commission of the offense. So now that was the instruction telling them that half of them cannot say he's not, and half of them cannot say, yeah, all of them has to unanimously agree. You're blocked. You're not blocked. Ivan, you can't be blocked. Hold on, y'all. We gotta fix that. Ivan cannot be blocked. Hold on. We gotta make that. Hold on. Let's fix that. We can't have Ivan. We can't have Ivan blocked. Hold on a second. Okay, Ivan, you're a moderator now, so you cannot be blocked. Okay, Ivan, there we go. All right, so let's go on to the next thing here. Type something, Ivan, because we can't have you blocked. We can't have you blocked. Who's blocking Ivan? We can't have him block, y'all. Forensic tech guy says they cannot validate the marriage certificate. It is impossible without everyone's signature. Clergy, bride, groom, and witness, all signature have to be proved. Exactly. Okay. Infamous Sylvia, you're doing a fantastic job. Oh, thank you, Star Child. Thank you. I thought I was boring you guys, but I'm not. Okay. So, let's go to the next one. All right, this is number 5. We're at number 5, right? Here's the next instruction. The request number 5, it says, all available evidence not need to be produced. Oh Lord, here we go. I hope there's not no shenanigan with them on this one here. Okay. The law does not require any party to call as witnesses all person who may have been present at the time or place involved in the case, or who may appear to have some knowledge of the matter in issue at this trial. Nor does the law require any person to produce as exhibit all papers and things mentioned during the course of the trial. All right, that was that one. That means that they don't have to have all the witnesses there. You don't have to have all the stuff there. That's that one. Number 6. Okay. Interviews of witnesses. Okay. There was testimony at trial that attorneys for the government and the defendant interview witnesses been preparing for trial. You should not draw any unfavorable inference from that testimony. To the contrary, the attorneys were obligated to prepare this case as thoroughly as possible. How the heck is supposed to prepare the case as thoroughly as possible when you guys are not giving the man the opportunity? This is crazy. Okay, I just had to put it in my little statement there. This is what they're saying, y'all. They letting Rob be behind the 8 ball. He's already way behind. Okay. You should not draw any unfavorable inference from that testimony. To the contrary, the attorneys were obligated. Here, you see, the attorney were obligated to prepare this case as thoroughly as possible and might have been directed to in the performance of their duties if they failed to interview witnesses before this trial began as necessary throughout the course of the trial. Oh, y'all. They're saying it's the responsibility of the attorneys to interview these people. So all those time that Steve and them 2 years of having this case did not interview anybody that was submitted to them, because I know some people that's been trying to get to Steve and them. They would not interview them. They would not talk to them. Okay, I know some people myself. Okay, all right, because I asked them, have you talked to the attorney? Yeah, they won't return my call. And Steve is really good for that, y'all. He was really notorious with that. Really notorious. He was up there. He wouldn't talk to nobody. All right, Michael, what did you say? Michael said, oh, you good for a while. Michael said they need to get on this case and set this man free already. I believe Rob is innocent. Me too. this goes to show you how they separated him from the whole situation, then make him the fall guy. Yup, Ivan. Yup. Here we go. Let's go on the next one. We're going to read the next one here. All right. This is uncalled witness equally available to both sides. Okay. Both the government and the defense have the same power to subpoena witnesses to testify on their behalf. If potential witness could have been called by the government or by the defendant and neither called the witness, then you may draw the conclusion that the testimony of the absent witness may have been unfavorable to the government or to the defendant or to both. On the other hand, it is equally within the province to draw no inference at all from the failure of both sides to call a witness. You must remember there is no duty on either side to call a witness. Okay. Whose testimony would merely be cumulative of testimony already in evidence, and who would merely provide additional testimony to fact already in evidence. Okay. All right. The next one is number 8. Opinion of defendant character, if applicable. Now, y'all, this is a big one right here. This is a big one. Opinion of defendant's character. The defendant has called witnesses who have given their opinion of his good character. This testimony is not to be taken by you as witnesses' opinion as to whether the defendant is guilty or not guilty. That question is for you alone to determine. You should, however, consider this character evidence together with all the facts and all other evidence in the case in determining whether the defendant is guilty or not guilty of the charges. Accordingly, if after considering all the evidence, including testimony about the defendant's good character, you find a reasonable doubt has been created, you must acquit him of all of the charges. On the other hand, if after considering all the evidence, including that of the defendant's character, you are satisfied beyond reasonable doubt that the defendant is guilty, you should not acquit the defendant merely because you believe him to be a person of good character. Request number 9, uncharged act considered for the limited purpose, if applicable. Did I get that one? Yes, please click the like button. You know, y'all, this is hard work now. Not only did this information, this is 89 pages, y'all. I'm not going to read all 89 pages, but this is like, you should show some appreciation to the channel by hitting that like button and sharing. That would be a nice thing for you to do. I mean, seriously, you're in here sucking up my information. Won't you just be nice enough and share it, and nice enough to click that like? And the only people that hit the dislike is people who's here being greedy, listening to my stuff, but then not being appreciative. It's always good to be appreciative. It's good to be appreciative, you know. That's biblical, you know. All right, let's go. Thank you, Empress. Thank you, Amber. Thank you, Miss Fat. Thank you, guys. I appreciate y'all. This is all to those who says I don't know how to read. I'm learning how to read right now because the more I read, the better I get at reading, you know. I'm just lazy sometimes. That's how I don't want to pronounce those words. Okay, that's just laziness. All right, here we go. Next one is request number 9, uncharged act considered in the limited purpose, if applicable. You have heard evidence that the defendant engaged in conduct, including crimes other than the crimes charged in the indictment. The defendant is not on trial for committing any act not charged in the indictment. For the acts committed outside the time periods charged in this count of indictment. Consequently, you may not consider evidence of those other acts as substitute for evidence that the defendant committed the crimes charged in this case. Nor may you consider evidence of those other acts as proof that the defendant has a criminal propensity. That is, may not conclude that he is likely committed the crime charged in the indictment because he was predisposed of criminal conduct. Instead, you may consider evidence of uncharged conduct by the defendant for the limited purpose, and you may consider it only the following limited purpose, which I will now describe. You may consider evidence of uncharged conduct. Here's the nonsense, y'all, okay? As evidence of the existence of the charged enterprise and evidence that the enterprise engaged in racketeering activity. Y'all hear this mess? As evident, the defendant's position or role within the enterprise. As evidence, the development of relationship of mutual trust between the defendant and others of whom he is charged with carrying out the charged crimes. As evidence of conduct that is extraditable, intertwined with evidence in charged crime. As evidence enabling you to understand the complete story of the charged crimes. As evidence in a modus operandi formed by the defendant and his accomplice to commit the charged crime, and as evidence corroborating the testimony of other government witnesses. Evidence of uncharged conduct by the defendant may not be considered by the purpose other than the ones I have listed. Okay, now we're at 10. Impeachment by prior inconsistent statement, if applicable. You have heard evidence that a witness made a statement on an earlier occasion, which counsel argues is inconsistent with the witness trial testimony. Evidence of the prior inconsistent statement was placed before you with the limited purpose of helping you decide whether to believe the trial testimony of a witness who contradicts himself or herself. If you find the witness made an earlier statement that conflicts with his trial testimony, you may consider the fact in deciding how much his or her trial testimony, if any, to believe. In making this determination, you may consider whether the witness purposely made false statement or whether it was an innocent mistake, whether the inconsistency concern an important fact, on whether it has to do with a small detail, whether the witness has an explanation for the inconsistency, and whether the explanation appealed to your common sense. It is exclusively your duty, based upon the evidence and your own good judgment, to determine whether the prior statement was inconsistent, and if so, how much, if any, weight should be given to the inconsistent statement in determining whether to believe all or part and none of the witness testimony. All right, number 11. I got that one, y'all? Oh, thank you, Nakia. Thank you, Michael. Impressed? I know how they do. You know how they do. They want to suck up my stuff. You know how they do. All right, here we go. Let's go to the next one. That's okay. They don't have to stay. All right, number 11. Number 11, number 11, number 11. It says here, you have heard the evidence about them. Okay, I forgot to read the top. Juries to consider only defendant on trial. You have heard evidence about the involvement of certain other people in the crime charge. You know what? This is the thing I don't understand. You say it's in an enterprise, right? But you only got one man charged with it. And then you're telling them that only consider the defendant on the trial. Don't consider the other people. What kind of craziness is that? All right. You have heard evidence about the involvement of certain others in the crime charge. You may not draw an inference, favorable or unfavorable, towards the government or the defendant from the fact that certain people are not on trial before you. That these other individuals are not on trial before you is not your concern. Dang! Woo! She said that is not their concern. Lord have mercy. You should not neither speculate as the reason these others are not on trial before you, nor allowed their absence as parties in the influence in the way your deliberation is in this case. Nor should you draw an inference from the fact that any other person is not presented on this trial. Your concern is solely on the defendant on the trial before you. Oh, crap. Y'all, did y'all hear that? I got to pause on that one. Hold on. Let y'all catch up to me. I'm letting y'all catch up. I'm waiting for your messages. The messages are delayed a little bit, but dang. They said it's not your concern if whether or not the other enterprise people are on it or whether or not why they're not on it. Oof. Ouch. Okay, I'm gonna go down to our next one. Whoo, number 12. All right, number 12, expert testimony. You have heard the testimony of what we call expert witnesses in this case. Ordinarily, witnesses are restricted to testify concerning matter of fact. There are occasions, however, when there is some technical or specialized area of knowledge that will assist the jury in deciding a disputed fact. On those occasions, a witness who specifically qualified by training, knowledge, experience, or education can be called as to testify in some evidence or fact in issues in the form of opinion. In weighing expert testimony, you may consider the expert qualification, the opinion given the witness's reason for testifying, as well as other consideration. The ordinary apply when you are deciding whether or not to believe a witness. You may give expert testimony wherever weight, if any. If you decide to deserve in light, if you find it deserved in light all of the other evidence before you, you should not, however, accept a witness testimony merely because he or she is an expert in the field. Nor should you substitute it for your own reason, judgment, and common sense. The termination of the fact is this: case rests solely with you. In short, the opinion of an expert is in all respect the same as testimony of other witnesses. Give it such weight as you think it deserves. All right, so the next one. Next one is number 13, particular investigative technique not required. You have heard reference in argument of the defense counsel in this case to the fact that the certain investigation technique were not used by the government. There is no legal requirement, however, that the government proves its case through any particular means. Oh, wow. So that means they got carte blanche. They could do whatever they want. Okay, that's my opinion on that one. Okay, next. While you are carefully considering the evidence adduced by the government, you are not to speculate as to whether they used the technique they did and why they did not use other technique. The government is not on trial. Law enforcement techniques are not your concern. Dang! The government technique is not your concern, y'all. These people are just so blunt. It seems like your concern is to determine whether or not an evidence or lack of evidence the defendant is guilty has proven beyond a reasonable doubt. Whoa, y'all. This is some blunt, some cruel stuff here. Woo. Venue refers to the location of the charged crime. Each count of the indictment alleges that the crime charge occurred in whole or part of the jurisdiction district, which is Eastern District of New York. This district includes Brooklyn, Queens, Staten Island, Long Island, Nassau, Suffolk County, and Long Island. Counties of Long Island, and the waters surrounding Manhattan. To establish a venue for the crime in this district, the government must prove, okay, this is a good one right here, y'all. The government must prove that the act in furtherance of the crime happened in the District of New York, Eastern District of New York. With respect to count 1, the racketeering count, the government needs to prove that some act in furtherance of the racketeering offense happened in the District of New York. And need not prove that any of all alleged racketeering act happened in District of New York. Wait. The government need only prove that the act in furtherance of the racketeering offense happened in the Eastern District of New York and need not prove that any or all of the alleged racketeering act happened in Eastern District of New York. I'm confused about that one. Unlike other element, the government must prove venue only by a preponderance, I can't say that word, preponderance of the evidence. That is, it is more likely than not some of the act furtherance of this crime occurred in Brooklyn, Queens, Staten Island, Long Island, and waters of surrounding Manhattan. All right, here we go, y'all. Okay, y'all ready for this? Y'all ready for this? Enterprise, company organized for commercial purpose, business firm or company, and a number of individuals assembled and associated together, group of people. This is ludicrous. Okay. So the hell with the others and alleged help a person to take advantage of children long as it's to get the man. Dear feds, you don't give a damn about the kids you're saying he did harm to. Trump won. Okay, Tony, what are you talking about? Tony, you need to get out of here. You're about to get blocked in a minute because we're on a different topic. And what are you bringing that up for? You're about to get blocked, Tony. You need to stop. All right. Okay, here we go. Y'all ready, guys? All right. Count 1 of the indictment charges the defendant with violating the Racketeering Influence and Corrupt Organization Act. Count 1 reads as follows. In or about and between 1994 and the present, both dates being approximate, and inclusive. Within Eastern District of New York and wherever elsewhere, the defendant, Robert Sylvester Kelly, known as R. Kelly, together with others being employed by, associated with the enterprise, an enterprise that engaged in the activity of which affect interstate foreign commerce, did knowingly and intentionally conduct and participated, direct and indirect, in the conduct of the affair of the enterprise through pattern of racketeering activity, as defined in Title 18 United States Code 1961, 1 and 1961, 5, consists of the Racketeering Act set forth below. The relevant provision of the racketeering status reads as follows. It shall be unlawful, listen y'all, listen to this. It shall be unlawful for any person employed by or associated with any enterprise engaged in the activity in which affect interstate and foreign commerce to conduct or participate direct or indirectly in the conduct such enterprise affair through the pattern of racketeering activity. To prove this crime, the government must first prove 5 elements beyond reasonable doubt. Number 1, first element would be an enterprise, as described in the indictment, existed on and about the time alleged in the indictment. 2, second, the enterprise engaged in and its activity affected interstate or foreign commerce. Third, the defendant was employed by or was associated with the enterprise. 4, the defendant knowingly conducted and participated in either direct or indirect the conduct of the affairs of the enterprise. 5, the defendant knowingly participated in the conduct of the affairs of the enterprise through patterns of racketeering activities, as described in the indictment, that is, through the commission of at least 2 of the charged racketeering act, the last of which must have occurred within 10 years after the commission of the prior racketeering act, and through causing or aiding and abetting the commission of 2 such racketeering act. I will now explain each element in greater detail. Okay, y'all ready? Y'all ready to hear this mess? Y'all ready? I'm gonna give y'all a minute to catch up to me. I'm gonna let y'all catch up to me. Y'all caught up to me yet? Give me a thumbs up if you're caught up to me. All right, y'all ready? All right, here we go. We're on another thing here. We're on another thing here. I see why people left now. All right, y'all ready, guys? All right, here we go. Now they're going to describe what this enterprise thing is all about. All right, you guys are ready? All right, here we go. It says here, first element, the existence of the enterprise. The first element the government must prove beyond reasonable doubt is that an enterprise existed. The indictment alleged the existence of the following. The enterprise, the defendant Robert Sylvester Kelly, known as R. Kelly, an individual who serve as managers, bodyguard, drivers, personal assistant, and runners for Kelly, as well as members of Kelly's entourage comprised of an enterprise. With the meaning of 18 USC 1961, number 4, that is, the enterprise constitute a group of people, of individuals associated in the fact that were engaged in the activity which affected interstate and foreign commerce. The enterprise constitute of ongoing organization whose members function as a continuing unit as for common purpose of achieving an objective of the enterprise. Number 2, the purpose of the enterprise is to promote R. Kelly's music and R. Kelly's brand, to recruit women and girls to engage in illegal sexual activity with Kelly, and to produce pornography, including child pornography. By promoting R. Kelly's music and R. Kelly's brand, the member of the enterprise is expected to receive financial opportunity and personal benefit, including increased power status within the enterprise. Y'all know that is a fallacy. That is totally a fallacy, y'all. A fallacy. A fallacy. You see that, guys? A fallacy. Number 3, in connection with the enterprise, Kelly and other members of the enterprise traveled through the United States and abroad to perform at concert venue and to promote R. Kelly's brand and to recruit women and girls to engage in illegal sex activity with Kelly. Y'all, that is a freaking lie. That was not the purpose of, guys. Number 4, when Kelly attended and performed at concert and other event, Kelly and or members of the enterprise on Kelly's behalf invited women and girls backstage on other events following Kelly's live performance. These women and girls were offered wristbands that signify that they were authorized to attend the event. There, Kelly relied upon members of the enterprise to ensure that only those authorized to attend were allowed at the event to manage the flow of women and girls who were directly interacting with Kelly. Y'all, this is some bull. This is some bull. Okay. Number 5, when Kelly identified a woman or girl who he wished to see again, he either gave his contact information to the women or girl or obtained their contact information and relied upon members of the enterprise to do so. Following these events, Kelly communicated with certain of these women and girls by telephone, including through the use of traditional telephone calls, text messages, iMessages, and FaceTime. As part of the communication, Kelly often requests the women and girls to provide him with a photography of themselves. You guys are with me? I see you guys leaving. They don't want to be educated, y'all. They don't want to be educated. You know what? This live, I'm going to take it down after I finish and let other people go find it themselves. All right, you here? Okay. All right, here we go. All right, so okay, now the next one, number 6. Number 6, it says Kelly and other members of the enterprise also arranged for the women and girls to travel to see Kelly's on occasion, including concerts throughout the United States and related events. To facilitate their travel, Kelly directed the women and girls to contact a member of the enterprise whom they arranged travel for the women and girls. When the women and girls arrived at the lodging, which was typically selected by a member of the enterprise, a member of the enterprise usually provided them with instruction. In addition, members of the enterprise took steps to ensuring that the women and girls did not interact with other women and girls whom Kelly planned to see. Members of the enterprise then arranged for women and girls to attend his concert and position themselves that Kelly could see them during the concert. Wow. Wow. Wow, God. Isn't that terrible? Guys, y'all see that? Hold on, I need to stop it for a second. Y'all see that mess? Hey, Michael, thank you for being here. Guys, y'all see here? You still here? Thank you. Thank you, guys. Thank you. Do y'all see that mess? But I don't understand something. Is it they the one who wants to go to these concerts and put these requests in? I'm lost. I'm really lost about this. Isn't it them that do that? Why isn't Charlie Sheen, who knowingly had HIV and admitted to having unprotected sex with women without telling them, why is he still on TV? What about Woody Allen? Thank you, sweet one. Thank you, sweet one. Thank you, sweet one. Thank you. Thank you. Thank you, y'all. This is crazy. This is really, really crazy. This is very, very crazy, y'all. All right, here we go. Guys, this is all about us being educated what's happening with Robert and what this case is all about, okay? We have to educate ourselves and be knowledgeable what is being said. So when we speak to somebody, we have the information. This is all about providing information and being staying abreast of what's happening, okay? Like I said, this channel here, we stay on the positive note. We're going to get the information that we need. We're going to stay knowing, knowledge is power. Knowledge is power. Then we'll be able to address some of the comments and things that's being said. As long as we are well informed of what's happening, and not letting our brother rot there and not having his constitutional rights being violated. And we need to know what the instruction that they're going to give to the jury. We need to know the instruction what's happening. We do. We need to. We need to be educated. We can't just sit around and just having these fun games and walking around here looking like buffoons. You know what I'm saying? Sambo, running like that. Oh, shucks. Got to be educated, guys. Got to be educated. My earring. Oh, yeah. We got to be educated. We have to be educated. We got to know the facts. We got to know what this man is up against, what the jurors is being instructed to do. We can't just sit around here and just act ignorant and be ignorant. That's what I'm here for. I'm here to provide to you guys what is happening. Hey, Tone. That's what I'm here for. Okay, let's go back. Let's go back in here. I'm going to share this again. Hold on, trying to bring it back up. Okay, I think so. Absolutely. All right. So we're at number 7 right now. We're going to read number 7. Can you guys see this? I see it, right? All right, we're at number 7. All right, number 7. Let's get going now. Let's get the information. Let's get power here. Speaking about Woody Allen, I watched his documentary on HBO Max. Whoa, so why he hasn't been locked? I don't know, Tone, because it's all about them messing with men that represent heterosexual strong men. If it's true, it's not a crime for Kelly having a desire to see express likes. Y'all, this is crazy. This is crazy. This is crazy. Okay, y'all. Let's get going. Let's stay focused, y'all. Let's stay focused on what's real here. Okay. All right. Thank you guys for being here. We're gonna focus on this case. We're gonna focus, not nonsense. Okay. All right. Here we go. Number 7. Kelly promulgated numerous rules that many of his sexual partners were required to follow, including A. The women and girls were not permitted to leave their room without receiving permission from Kelly, including to eat or go to the bathroom. Yeah, y'all notice how they put his name in capital letters as an enterprise? Capital letters. You know, when you do your name in all capitals like that, it shows a business. They put him as a wow, not the person. They're doing him as the so-called enterprise capital. You notice, you see the word game, the play game they're doing, right? They're not putting his name as in K, capital K, small letter Lelly. They put it all capital letters. Y'all see that, right? Okay. All right. The women and the girls were not permitted to leave their room without receiving permission from Kelly, including to eat or go to the bathroom. B. The women and girls were required to wear baggy clothing when they were not accompanying Kelly to any event unless otherwise instructed by Kelly. C. The women and girls were not permitted to look at other men and instead were told to keep their heads down. D. The women and girls were required to call Kelly daddy. 8. The enterprise operated within Eastern District of New York and elsewhere, including overseas. Method and means of the enterprise. Among the means and methods by which Kelly and his associate participated in the conduct of the affair of the enterprise were that the following: A. Committing and attempting, aiding and abetting, and commission of crimes, conspiring to commit crimes, including but not limited to engaging in sexual activity with girls under 18, engaging in and facilitating sexual activity without disclosing a sexual transmitted disease. Kelly has contracted producing child pornography, bribery, extortion, and coercion, and blackmail. B. Demanding absolute commitment to Kelly and not tolerating dissent. C. Obtaining sensitive information about sexual partners and members associated in the enterprise to maintain control over them. D. Creating embarrassing and degrading videos of sexual partners and to maintain control over them. E. Recruiting, grooming sexual partners for Kelly. F. Isolating women and girls from friends and family and making them dependent on Kelly for financial well-being. The term enterprise, as used in these instructions, may include any group of people associated, in fact, even through the association of not recognized as a legal entity. Thus, an enterprise need not to be a formal business entity, such as a corporation, but may be merely an informal association of individual. The term enterprise includes legitimate and illegitimate enterprise. Enterprise can be a vehicle used by the defendant to commit crimes. The enterprise does not have to have a particular name, or for that matter, any at all, nor must it be registered a licensed enterprise or be commonly recognized as legal entity such as a corporation, a partnership, a business, or an act. A group or association of people can be an enterprise if these individuals have associated together in a common purpose of engaging in a course of conduct. Merely similarity of a conduct or the fact that the individual may have assembled together and discuss common aim and interest does not necessarily establish proof of existence of an enterprise, though you may consider such fact. Such fact associated of a person may be established by evidence showing an ongoing organization, formal or informal, and by evidence that the people making up the association function as a continuing unit. The government must prove an association, in fact, enterprise existed by evidence of an ongoing organization, formal and informal, by evidence that the various associates function as a continuing unit. The enterprise must have the following structural feature. 1, purpose. 2, relationship among the associate with the enterprise. And 3, longevity sufficient to permit the associate to pursue the enterprise purpose. It is not necessary that the enterprise have any particular form of structure. It may have sufficient organization that is, the members function and operate in a cooperative, coordinated manner in order to carry out the alleged common purpose or purposes for enterprise. Such a group need not a hierarchy structure or a chain of command. Decision may be made at an ad hoc basis and any number of method by majority of vote, consensus, and shows of strength. Members of a group need not to have fixed roles. Different members may perform different roles in different times. The group need not have name, regular meeting, dues, established rules, regulation, disciplinary procedures, or intention procedures. Y'all, this crap is anything. They did a big blanket on this whole thing, y'all. A big blanket. Wow. A big blanket. It could be anything. Even if him having friends for 30 years, and if the friends decide to have a relationship with somebody, they putting that as part of the enterprise. Just like Bubba having a relationship with Geronda. They're putting it as an enterprise. Wow. Okay, I'm done on this one. Oh my God. I'm done. I'm done. I'm done. I'm done. I'm done. Marquin, I'm done. Yeah, they're making it like, this is crazy. The government's putting a big blanket over this. Like, okay, like the bodyguards decide to have sex with somebody to let them into the venue. They say to them, okay, in order for you to see R. Kelly, you got to sleep with me. So now that's going to be put on Robert because they chose to want to have sex with that person, which has nothing to do with Robert. I'm done. I'm done. I'm done. This is crazy. All right, y'all. I'm going to take a break after this. I'm gonna take a break. They are out to get him, y'all. Only God, Lord, Father God, in the name of Jesus, help Robert, help Robert. That's why I was telling you guys, best for us to get educated. This is why it's best for us to get educated what's happening. Sweet one, Judge Brown is not going to look at that stuff right now because it's an active case. He can't give legal advice. He can't do that kind of stuff. Amen. Thank you, Tone. Thank you, Tone. Thank you, guys. I'm gonna give me about I'm gonna take a break for a minute because we're at the 2-hour mark. Take a break, get something to eat, and then I'm gonna come back on so we can discuss this further. How did that sound? Because I need you guys I need us to read this and see what's going on. I could send it to him, sweet one. I'm gonna send it to him. I'm gonna send it to him just to see what he says. I'm just send it to him. Oh, speaking of send it to him, today is his birthday. Let me send him a message. Happy birthday. Hold on a second. Today is Judge Brown's birthday. Say happy birthday. Happy birthday. Okay, I just sent him a happy birthday. Okay, I'm gonna take a break. I'm gonna go to get something to eat. Or let me see. Should I go on and stop at another point? Hold on a second. Let me not stop in the middle of this. Let me go down a little bit and then come back and stop at a certain spot. Let's do that. Okay, All right, I'm gonna go back up and then finish what I was reading and then stop and then we can take a break. How does that sound, y'all? This is crazy. This is crazy. This is very crazy. How does that sound? Y'all wanna okay, I understand. I'm wondering, okay, I'm cool with that. Yeah. So just we can have an idea of what's going on in the case. He doesn't have to give an opinion, but he's aware of it. Okay, I'm gonna send it over to him, sweet one. Has anyone I have seen as much in my time. I hope the new lawyer is a pit bull. Thank you so much for breaking this down for us and keeping us informed. You're so welcome, sweet one. Keep going. Okay, Bree, I'm going to keep going. Sounds good. I understand you. I hope that as well. All right, we'll go ahead and continue this one here, and then we're going to stop at a point because I hate to stop in the middle like this. So we're going to go ahead and finish reading this one. And okay, hold on a second. Yeah, guys, could y'all post Miss Fat, if you still in here, could you post Peter's link to the thing so I could you post it in our little chat, Miss Fat? If you're here, because somebody needs it. Miss Fat, could you just post it in Peter's link in our Facebook chat, please, if you don't mind, please? All right, okay, we're going to finish reading this. I see a lot of people left because I guess they thought I was leaving. You know what? Let's just take a break. I'm going to leave the page where I'm at left off, and then we'll take a break. We'll take about a 30-minute break and come back. Thank you, Miss Fat. No, put it inside of our group chat. Put it inside our group chat, if you don't mind. Yeah, I saw the interview. It was interesting. I was gonna see, the thing is, if y'all notice the way when the judge is answering question in regards to Robert, he's very vague. He can't really address Robert's case because it's an open case. It's a very open case, and him being a judge, ex-judge, there are certain guidelines he has to go through. And like when we're asking him questioning here, he can't give his opinion. He was able to give his opinion in Bill Cosby case because Bill Cosby case has already been through trial and things like that. With Robert's case, it's an ongoing case right now, so he cannot really speak about it. Now, once everything has been decided, then he can speak up and give his viewpoint on that. Okay, but right now, and I know a lot of people gets mad at him. He can only talk about what the indictment is or what's going on in the case. He cannot talk about his true outlook on it. Okay, he just couldn't give you what he's being charged with. Now, I know a lot of people got upset because he wouldn't address some of the statement. He'll make statements as regards to the law, but as far as the case itself, he really cannot speak on. Okay. Peter is not going to come to trial, but I'm going to get Peter to come on here and talk to you guys. Let me see if he's available right now. If he's available right now, I'll get him to talk to you guys. Thank you, Miss Fat. Appreciate you, darling. Thank you, Miss Fat. Thank you, Miss Fat. You're on it, young lady. Thank you, darling. All right. Yeah, exactly, Daddy Lola. You see what he said. He said the man is innocent. And I know a lot of people wanted him to give his opinion about the case. He really cannot. He really cannot. Not until it has been tried and completed, And there's certain guidelines you have to do because, as a judge, his word holds a lot of weight. And it could be like jurors that's looking at him, and then they hear him say certain thing, they'll be like, oh, okay, we're not, you don't want him swaying the jury at all. So, and he's very, very popular, and his word carries a lot of weight. So he has to stay back and neutral. Okay. I'm not too sure if Peter could be in New York, but let me reach out to Peter. Hold on a second. And you guys, I hope you guys understand as far as what Judge Joe Brown, his stance is on certain things. He just can't give his opinion on anything. He just has to go with what the law is. And the law said he's innocent until proven guilty. Yeah, see, Tom Mesereau says the same thing. You gotta let the case go out because you can't give an opinion of it, especially when you have so much strength, as far as the law. And I know a lot of people pissed off of what the statement he had made in regards to what the case says. He can talk about what the case says, but he cannot give you his opinion on what. Hold on, y'all. Just 1 second. We're trying to get Peter. Let me see if I can call him. Hold on, call Peter. He gave me his number in Africa. I don't have long distance like that. I try to call him on I don't think he's available. He's not answering, y'all. He's not answering. He might be sleeping. Thank you, Lavelle. Lavelle says, even though the judge is retired, he still has guideline he has to follow and is very limited to what he can say on an ongoing case. Thank you, Lavelle. But he'll be back. He'll be back on my channel. He promised me he's coming back on. He was supposed to be on yesterday, but I had to work. I had stuff to do. But he'll be back on. All right, I need to take a break, y'all. I need to get myself together, like eat something. And I'll be back to you guys in a minute. Give me about an hour. I will be back on for real, because sometimes I used to say I'll come back on and don't come back on because stuff start happening here, and then I gotta get I'm set time off today to bring you guys some information. Okay. All right. I'll see you guys in a few. Later. I'll be back. I'm gonna set my time on for real. So I'll be back about 3:30? Be back in 1 hour. Gotta take a lunch break. Bye.